Good afternoon. I want to welcome you all to our 4th annual Rosenkranz debate. I want to express our gratitude to the Rosenkranz Foundation for supporting this event, and to Nick also for suggesting this a couple years back as the perfect Saturday centerpiece for our convention. An intellectually sharp, one-on-one debate between two highly prominent legal theorists. This series had a wonderful start in 2008 with a discussion between Judges Richard Posner and Mike McConnell. In 2009, the debate featured Judges Guido Calabresi and Frank Easterbrook. Last year, Richard Epstein and William Eskridge. To moderate this year's debate, I want to introduce Nick Rosenkranz, who is a tenured professor at Georgetown Law School and who is the author of 2 major articles on constitutional interpretation, Subjects of the Constitution and Objects of the Constitution. I turn it over to you, Nick.
Thanks very much. Thanks, Gene, and thank you all for joining us today. In our panels, we try to give you 3 or 4 different perspectives on various topics, but today, on Saturday, we try to give you something a bit sharper, more pointed. So today, we try to present opposing views on legal issue of the day. Today we're going to be discussing perhaps the single most important pending issue. We have 2 of the finest advocates in the country to debate it. So our resolution concerns the constitutionality of the recent healthcare law. This could not be more timely. The D.C. Circuit issued an opinion about this just a few days ago. Cert petitions are already pending, and we're expecting word from the court as early as Monday on this. So our format today is going to be 15 minutes, and then 15 minutes, and then a rebuttal, 7.5, 7.5, and then perhaps a slightly more informal discussion, possibly egged on by your humble moderator. And then, if time permits, we'll take some questions from the audience. So today we have 2 great debaters to engage in this topic. The first on my left is Professor Laurence Tribe. Professor Tribe's the Carl Loeb University professor and professor of constitutional law at Harvard. He's a much sought-after appellate advocate as well as a distinguished academic. Tribe has prevailed in 3/5 of the many appellate cases he's argued, including 35 at the U.S. Supreme Court. He holds the title University Professor and has held it since 2004. It's Harvard's highest academic honor. It's awarded to just a handful of professors at a time and fewer than 70 professors in Harvard's history. Tribe was appointed in 2010 by President Obama and Attorney General Holder to serve as the first senior counsel for access to justice. Currently serves as a member of the President's Commission on White House Fellowships and has written 115 books and articles, including his treatise, American Constitutional Law, which is cited more than any other legal text since 1950. Speaking as someone who teaches and writes about constitutional law, this book is simply invaluable, indispensable. I turn to it all the time. Tribe entered Harvard at 16, graduated summa cum laude in mathematics and magna cum laude in law, clerked for the California and U.S. Supreme Courts, received tenure at 30, was elected to the American Academy of Arts and Sciences at 38 and the American Philosophical Society in 2010, helped write the constitutions of South Africa, the Czech Republic, and the Marshall Islands, has received 10 honorary degrees. Welcome, Professor Tribe.
Thank you, Nick.
To my right, we have Paul Clement, a partner at Bancroft, PLLC. Mr. Clement served as the 43rd Solicitor General of the United States from June 2005 to June 2008. Prior to his confirmation as Solicitor General, he served as acting Solicitor General for nearly a year, Principal Deputy Solicitor General for over 3 years. His more than 7 years of service in the Office of Solicitor General is the longest period of continuous service by a Solicitor General in that office since the 19th century. He's argued over 50 cases before the U.S. Supreme Court, including McConnell v. FEC, Tennessee v. Lane, Rumsfeld v. Padilla, Credit Suisse v. Billing, U.S. v. Booker, MGM v. Grokster, and McDonald v. Chicago. Paul Clement received his bachelor's degree summa cum laude from Georgetown School of Foreign Service, master's degree in economics from Cambridge, graduated magna cum laude from Harvard, where he was a Supreme Court editor at the Harvard Law Review. Following graduation, Mr. Clement clerked for Judge Laurence Silberman of the U.S. Court of Appeals for the D.C. Circuit. That's the judge who issued the D.C. Circuit opinion just last week, coincidentally. And clerked for Associate Justice Antonin Scalia at the U.S. Supreme Court. Welcome, Mr. Clement. So our resolution for today is resolved. Congress acted within its authority in enacting the Affordable Care Act. And we'll hear first the pro side from Professor Tribe.
Thank you very much, Nick. It's a great honor and pleasure to be here and to be debating my friend, the distinguished former Solicitor General, Paul Clement, on a constitutional question of great importance. I can't imagine a more interesting and important topic or a worthier opponent. In March of last year, Congress enacted the Patient Protection and Affordable Care Act, to which I will refer lovingly simply as the Act, to cope with what it believed was a crisis in the $2.5 trillion healthcare industry, accounting for 17% of our GDP and covering an array of providers, consumers, supply chains, and financing schemes operating across state borders. In Congress's view, the crisis is basically that tens of millions of people have no health insurance, some because they cannot afford the premiums, others because they are denied coverage by restrictive industry practices, still others because they choose to gamble that they will never need health care beyond what they can pay for out of pocket. Yet virtually all of these people participate actively in the health care market, and many end up consuming health care services for which others pay. Because a basic feature of American law and culture is that hospitals cannot turn away people who need emergency treatment, making the healthcare market unlike any other in our society. The result is that uninsured patients end up inefficiently shifting well over $73 billion a year in healthcare costs to other market participants, raising the average family's annual insurance premium by about $1,000, making health insurance unaffordable for even more people, increasing taxpayers' health-related burdens by at least $30 billion, and making the healthcare crisis still worse. After extensive study, Congress chose to address this vicious cycle through a comprehensive program of tax measures and market regulations. The Act builds on the existing nationwide system of employer-based health insurance by creating new tax incentives for businesses to pay for insurance for their employees, provides for the creation of health insurance exchanges through which individuals, families, and small businesses can leverage their collective buying power to obtain health insurance at more favorable rates, establishes federal tax credits to help households with incomes between 1 1/3 and 4 times the federal poverty level to buy insurance on those exchanges, expands Medicaid eligibility to cover those with incomes below 1 1/3 times the federal poverty level, with the federal government paying all of the added expense through 2016 and all but about 10% beyond 2020. Forbids insurance industry practices that have kept individuals from obtaining and maintaining health coverage because of pre-existing medical conditions, and requires that premiums be based on community-wide criteria rather than on a person's individual medical history. And finally, it amends the Internal Revenue Code in a manner that Congress expressly found essential to make these reforms of restrictive industry practices work. The Act does that by providing that a non-exempt individual who fails to maintain a minimum level of health insurance and who is not otherwise covered has to pay a tax penalty calculated as a percentage of household income, capped at the price of the foregone insurance coverage, reported on the individual's federal tax return, and assessed and collected the same way other assessable tax penalties are civilly collected under the Internal Revenue Code. The Congressional Budget Office estimates that imposing this tax penalty as part of the Act's comprehensive reforms will induce about 16 million otherwise uninsured people under the age of 65 to purchase health insurance without waiting until they need care, while raising about $4 billion in tax revenue from people who opt to pay the penalty rather than purchase the required insurance. The other provisions, it's estimated, will reduce the number of uninsured people under the age of 65 by about 17 million, bringing to 33 million the added number who will be insured. Now, there are any number of excellent arguments, both for and against the Act as a policy matter. Clearly, they are not the issue here. The issue is simply the constitutional one, and the principal constitutional claim against the Act is that Congress has no affirmative authority to create this federal income tax incentive for the uninsured to buy coverage in advance of need. First, because the Act's mandate wasn't clearly labeled a tax and didn't specify that those who pay the tax penalty rather than purchasing insurance are acting legally. And second, because viewed strictly as a regulation of when and how health care gets paid for, the Act operates not at the time someone actually consumes health care, but in advance. Now, the one circuit court that struck down the mandate, the 11th Circuit, conceded, as have Paul's clients in that court, that when the uninsured consume health care, Congress may regulate their activity under the Commerce Clause by conditioning that consumption on their being insured or paying a penalty. So the obvious question is, why not a moment earlier? The theory is that a moment earlier, the consumption of health care is merely a future probability, an economic forecast. But of course, everyone is always at risk of needing health care at any instant. No one can predict when unusually costly health care will be needed and made available, even if one can't pay. Indeed, most costly medical procedures needed by people under 65 are the result of some unpredictable bolt-from-the-blue event, like a car accident or a stroke, that we know will happen on average, but can't predict to whom or when. Clearly, no health insurance market could survive if people could buy their insurance on the way to the ER and dump it the moment they leave the ER, which they could do without any penalty under a system that, like the Affordable Care Act, prevents insurers from charging patients based on their medical situation or excluding patients based on pre-existing conditions. But as Judge Jeffrey Sutton of the Sixth Circuit observed when upholding the individual mandate, and I quote him, "Requiring insurance today and requiring it at a future point of sale amount to policy differences in degree, not kind, not the sort of differences that are removed from the political branches by the Constitution." Judge Laurence Silberman of the D.C. Circuit, joined by Judge Harry Edwards, reached the same judgment in upholding the Act's constitutionality just 4 days ago. Perhaps if you'd been clerking for him now rather than earlier, things would have been different, but I don't know, because he relied on an analysis that was, if anything, broader than that of Judge Sutton. He held that, and I quote, "the power to require the entry into commerce is symmetrical with the power to prohibit or condition commercial behavior, reasoning that the power of Congress to regulate instances of ostensible inactivity inside a state is as broad as its power to regulate purely local conduct when the two are equally injurious to interstate commerce." He went on to explain why, in any event, drawing an activity-inactivity line would not preserve state sovereignty. But as Judge Silberman also observed, for this legislation, one needn't go that far. For this legislation, and I quote him, "It suffices to recognize that the health insurance market is a unique one, both because virtually everyone will enter or affect it, and because the uninsured inflict a disproportionate harm on the rest of the market as a result of their later consumption of health care services. Now, the only response to these quite compelling constitutional arguments from notably conservative jurists has been that financially penalizing the failure to purchase insurance in advance is somehow akin to forbidding the possession of guns near schools, which we know Congress may not do. Both have economic and interstate effects, but according to the law's challengers, remaining uninsured, like merely possessing a gun near a school, is not an economic activity as such. Apart from Judge Silberman's cogent demonstration of why that would be a distinction without a difference, it's also a distinction that defies reality. For arranging how to finance one's eventual medical care and arranging to have other people bear the risk of financing it is an economic activity on its face. And in any case, it seems to me that there is all the difference in the world in terms of core principles of federalism between using federal criminal law to ban gun possession near a school, which the court said Congress couldn't do in Lopez, or overlaying a federal cause of action on top of a state system for coping with gender violence, which the court said Congress couldn't do in Morrison, and simply adjusting someone's pre-existing federal income tax liability to reflect the way in which that taxpayer makes the quintessentially economic choice of financing the health care that the taxpayer, like everyone else, is constantly at risk of needing. The contrary view depends on depicting a taxpayer's choice to remain without health insurance as non-economic, and describing a tax penalty for making that choice as a way to conscript the taxpayer into commerce, rather than a way to regulate that taxpayer's economic behavior. Well, even if that were so, it would be constitutionally irrelevant, but it's not so. Increasing people's income tax liability for making choices that directly and immediately increase other people's premiums in the interstate health insurance market and raise other people's health-related taxes across the country does not involve conscripting people into a stream of commerce to which they would otherwise be strangers. The conscription view is an optical illusion caused by focusing too narrowly on moments at which a healthy individual doesn't happen to be using health care services. That freeze-framed still, captured like a photograph in a single moment in time, to quote Judge Marcus of the 11th Circuit, overlooks how virtually all of us swim in that stream at some point, most of us often, and how none of us, unless we're religious objectors whom the Act exempts, can arrange never to swim in it. As for the rest of us, we can decide never to participate in the narrower streams or tributaries of commerce for things like annual checkups or gym memberships, or for that matter, for healthy foods like broccoli. The Act leaves all of us alone when we make those individual decisions. In fact, it does not intrude on anyone's bodily integrity, nor compel anyone to adopt an unwanted lifestyle or accept unwanted treatment, something that long-settled substantive due process principles protecting personal liberty rightly refuse to permit either Congress or the states to do. But none of us can decide to remain permanently outside the broad stream of commerce for health care. And all this Act does, at bottom, is to regularize the economic arrangements by which our inevitable participation in that stream is to be funded, using the Internal Revenue Code to collect an income tax surcharge if we insist on making economic choices that burden our own families and others, driving up taxes and insurance premiums as though we were islands unto ourselves. But of course we're not, and the Constitution does not compel Congress to treat us as though they were. Put otherwise, all of us are swimmers in the broad stream of medical commerce. The only issue is whether we will swim uncovered rather than covered by insurance. And by requiring that we cover ourselves with insurance, or else pay our fair share of what swimming in the nude ends up costing other people, Congress is not crossing any line that constrains its constitutional authority. So the Act's individual mandate is sustainable first as a Commerce Clause regulation of classically economic behavior with substantial interstate effects. Second, as a regulation that's necessary and proper to making the rest of the Act's comprehensive structure work effectively. Third, as a provision that operates simply through adjusting people's federal income tax liability rather than invading or displacing any sovereign state function. And fourth, as a measure that fits comfortably within the zone in which the Constitution's framers saw a functional need to empower national action, given the structural difficulties that would beset efforts by individual states to cope with the problem at hand. Because obviously any state that tried on its own to solve the problems of the uninsured, whether by being more generous in terms of medical benefits or by imposing tighter restrictions on health insurance companies, risks turning itself into a magnet for the needy and dependent and prompting insurers to move to other states. That race to the bottom further distinguishes the problem. That Congress chose to tackle at a national level in the Affordable Care Act from the kinds of purely local problems into which the court held Congress could not inject itself in Lopez and in Morrison. So along these four distinct axes, Congress acted within its constitutional authority. As Judge Silberman observed Tuesday, the Act's mandate may be novel, but its opponent's proposed constitutional limitation is equally novel. And as he concluded, the novelty cuts the other way, because we are interpreting the scope of a long-established constitutional power, not recognizing a new constitutional right. If the question were a close one, the judiciary's clear duty would be to defer to the hard-won results of the democratic process, whether one likes the policy outcome or not to substitute its policy judgment for that of the people's elected representatives in the two political branches. But in truth, although the political question may be a close one, I genuinely believe that the constitutional question is not. I guess I may have a minute left, but who's counting?
Paul Clement.
Well, thank you, and let me start by saying what a pleasure it is to be here today, and it's an honor, I think, especially for any graduate of Harvard Law School to be in a debate with Professor Tribe is a distinct honor, so I'm very happy to be here. There's certainly much in what Professor Tribe said about the background of the Act that I agree with. There's certainly some differences between the two of us. For example, I plan not to quote at length from Judge Silberman's opinion. But I do think his description of the Act is accurate. I want to just make 3 points about the background of the Act and then just lay out the relatively simple argument, I believe, that makes clear that the Act is unconstitutional. And I should say that this is an Act that is hundreds of pages long. I'm not sure any of the legislatures that voted for or against it have read the entire thing. And I would certainly bet all the money in my wallet that there's at least one provision in this statute that's unconstitutional. It may not be one anybody's even read yet, but it's out there. But I'm going to focus just on the individual mandate for the sake of convenience and with respect to the limits of time. Now, in describing the Act, the one thing I just highlight is Professor Tribe was very accurate in describing the textual reference to the citizens in this Act as non-exempt individuals. And I would just say any act of Congress that refers to the people of the United States as non-exempt individuals ought to raise some concerns right there. I also want to clarify something which I think is actually important in understanding the way that the Act works, which is that it is often referred to as the individual mandate. Professor Tribe accurately refers to some of the provisions in the Act that reference the tax code and make it seem more like a tax provision. But what I think is very important to understand is that the Act has both a mandate, which is enforceable by a penalty, and they really are separate. They operate separately. There are individuals who are subject to the mandate who are exempt from the penalty. So if you have income below a certain amount, you are subject to the mandate, rather. You still must go out and purchase health insurance, but you are not subject to the penalty. So they're distinct. And I really want to focus on why the mandate is unconstitutional. And then the next thing I want to point out, which I think is very important, and in some ways the debate here may come down to this distinction, though I think the issues here run much deeper. But Professor Tribe, as almost any advocate defending this law would do, wants to focus your attention on the healthcare market. And this is all about the healthcare market, and all the regulation and the mandate does is regulate the timing of your participation in the healthcare market. I don't believe that's true. I believe what this act clearly involves is not the healthcare market, but the market for healthcare insurance. It's a mandate that forces you to buy insurance. It doesn't care whether or not you use it when you enter the market. Nothing in the statute, even if you buy the forced government policy, nothing in the statute requires you to use it when you walk into the hospital. So this is about forcing people to buy health insurance, forcing people who would otherwise consciously decide to make a rational economic choice not to buy health insurance. And that's what this statute's about, and that gets to the nub of why it's unconstitutional. The argument for its unconstitutionality, I think, is relatively simply stated. And the place to start, as it is with any decent constitutional argument, is with the text of the Constitution. And the Commerce Clause in particular, many of you who haven't looked at it and have just sort of heard snippets about the Commerce Clause and how it's described may be surprised to learn that it doesn't refer to plenary power or to police power. It refers to the power to regulate commerce. And the fundamental problem with this act is that forcing somebody to engage in commerce so that the government can better regulate commerce is not the regulation of commerce. When you force somebody to engage in commerce, you don't regulate commerce, you make commerce. And that's not what the Commerce Clause is all about. Now let me elaborate, and let me start with what may seem like a weakness. Professor Tribe correctly points out that the challengers in this act rely, among other things, on the Lopez case and the Morrison case. And part of the explanation for that is, of course, that beyond the Lopez and the Morrison case, the breadth of the modern Commerce Clause, as understood by the Supreme Court, is broad indeed. And that may seem like a weakness for somebody making a Commerce Clause challenge. And I'll acknowledge at the outset that making a Commerce Clause challenge to the current court is a difficult task. Many people have tried. 2 have succeeded, Lopez, Morrison. And so you'd think that the breadth of the modern Commerce Clause would be a problem. But I don't think so, because it's important to understand the consequences of the argument that this is constitutional. If this is constitutional, then what you get at the end of the day is the full breadth of the modern Commerce Clause that covers almost everything, and yet you have the depth of government power that they can force you to engage in all of that commerce to better regulate you. And when you look at the breadth and the depth of the power asserted, there's nothing left. That basically covers the waterfront. And if you think about the breadth of the modern Commerce Clause power of the government, I think it's fair to say that one of the very few things any citizen can do to avoid the regulatory power of the federal government is to refrain from commerce. That's about it. I mean, maybe you can stay within 1,000 feet of a school zone, and that'll help a little bit. But basically, if you want to avoid the federal regulatory power, all you can do is simply exercise your right to not engage in commerce. But if this law is constitutional, then you don't have that right either. The federal government, as part and parcel of its Commerce Clause power, can force you to engage in commerce so that they can better regulate the commerce. So in that sense, I actually think the breadth of the modern Commerce Clause is a blessing, not a curse, for the challengers to this law. And I think in terms of the breadth of that commerce and then combining it with the power to mandate people to engage in commerce, I think it's worth taking a brief thought experiment, if you will. Because let me start with the observation that some people in defending the act, Professor Tribe did not, but some people in the act, defending the act, make the point that, well, what's so special about forcing people to engage in a certain activity? I mean, we have, the draft. The draft involves that kind of compulsion, and most people think the draft is perfectly constitutional. I mean, some don't, but many think that that's constitutional. Well, I think, though, it's the striking difference between the draft and what's asserted here goes precisely to the narrowness of the powers that might give rise to a draft and the breadth of the modern Commerce Clause. And then here's the thought experiment. Imagine, if you will, for a minute, that the framers of this great country actually conceived that we would have a Commerce Clause power that's as broad as the modern Commerce Clause. And then think for a moment if they thought that that Commerce Clause power included the right to the power to force people to engage in commerce so that the federal government could better regulate them. I would submit as a thought experiment, think about how many provisions there would have been in the Bill of Rights. I don't think they would have stopped at 10. I think there would have been 20 provisions, and 10 of them would have been specifically directed at limiting this enormous, unbelievable power asserted by this new federal government. And I think in an odd way you see that. I mean, to the extent that the draft was part of the power to raise a standing army, that explains why the Second Amendment and the Third Amendment was in the original Bill of Rights. Because that power, because it perhaps included the power to compel, was a particularly dangerous power. And in the same way, if you imagine a power as broad as the modern Commerce Clause that included the power to compel, I think we'd be talking about the Bill of Rights as the first 20 amendments to the Constitution. Now, let me say something else about this, which is, and this will be the only respect in which I quote the majority opinion from the D.C. Circuit. But one thing that's clear that even the courts that have struck down this act have recognized is the lack of a limiting principle in the government's argument in defense of this statute. That's basically the starting premise for the D.C. Circuit opinion. Ultimately, the D.C. Circuit opinion didn't find that fatal. But there is no limiting principle for the power asserted. And Professor Tribe, as any good advocate on his side of this issue would do, points to the uniqueness of the healthcare market. But the problem is, uniqueness is not a limiting principle. Uniqueness might explain why this is the first time Congress has used this power, but it doesn't explain why, if this congressional power is upheld, it will be the last time that it's used, because it won't. I mean, this power that we're talking about here is an incredibly dangerous power. And many people, and I know there's some judges in the audience, they don't like arguments that are of the kind that, you know, the dog that didn't bark. But I submit here is a dog that didn't bark argument that is very powerful, which is if Congress really did have this power, I think it is astonishing that they would have waited 220 years to exercise it. This is such an amazing power that's being asserted on behalf of the Congress. And just think about recent situations. I mean, who needs cash for clunkers? You could force people to buy cars. How much more efficient? Or, I mean, you know, think about other programs here. I mean, you know, even think about, let's say it, Wickard against Filburn. Why were we fooling around back then in limiting the production side of the equation for wheat? We could have just forced people to buy wheat, and that would have been much more effective at accomplishing the government's objective. Or take flood insurance, and one of many examples of why health insurance is not so unique. There are many other markets that work this way. Flood insurance. How does the government try to get people to purchase flood insurance? They do it as a regulatory part of federally backed mortgages. Now, why in the world would they use that indirection when what they really wanted to do is make sure everybody in the floodplain had flood insurance? Well, if this law is upheld, I don't think they'll fool around with making it a condition to mortgages in the future. Let me say one thing else about the lack of a limiting principle here. I think this is, despite the D.C. Circuit opinion, ultimately a fatal aspect of this statute. And if you look at the recent history of Commerce Clause cases in the Supreme Court of the United States, the federal government loses these cases when it cannot articulate a limiting principle. And why is that? Because the court is conscious that as broad as the modern Commerce Clause power is, it cannot be made the equivalent of a plenary power. The whole court is, I think, recognized that the very process of enumeration of powers assumes certain powers not enumerated. And if the Commerce Clause is made to be a plenary power without limits, then the whole process of enumeration has essentially been an empty exercise. And that is why I think that the government in this case will be asked over and over again, what's the limiting principle? And that's why I think ultimately, although many people look to this D.C. Circuit opinion and say, look, the D.C. Circuit struck this down, I think ultimately the D.C. Circuit opinion holds the key to why the government will not prevail at the end of the day, which is its explicit acknowledgement that there is no limiting principle here. Now let me say, as I start to wrap up, that there are at least 3 reasons why I think this case is so important and why, in fact, these limits have to be imposed on the power that's asserted here. The first is in terms of the states. The states in our constitutional system play a very important role And one of the few things that defines their continuing role as distinct from the federal government is the fact that, as Justice Kennedy has acknowledged on more than one occasion, the police power does not reside with the federal government. The police power resides with the states. And so in a case like this, when the federal government asserts this kind of limitless authority without limiting principle, I think that's when they get themselves into trouble with the court, in part because it gives the lie to the process of enumeration, but in part because it's too threatening to the residual sovereignty of the states or the residual dignity of the states, as Justice Kennedy would put it. Second, liberty. Justice Kennedy made clear for the court just last term in the Bond case that federalism and the separation of powers exist not to protect the branches of government or the states alone, but to ensure individual liberty. And I think this case is about the best case you could imagine for making that point. The power asserted here to mandate individuals to engage in commerce is not a power that one would lightly give to the federal government in this country without grave concerns for liberty. So Judge Silberman, in his opinion, makes the point that, well, this liberty interest seems like more of a substantive due process argument than it is a Commerce Clause argument or an enumerated powers argument. But I think that makes a categorical mistake, which is the Bill of Rights are not the only thing that protects liberty. The federalism principles in the Constitution protect liberty. And again, I think the fact that if you were looking at this only as an individual liberty case, you'd have to resort to substantive due process, actually is helpful. Because the reason there isn't a specific constitutional provision, the reason you'd have to rely on substantive due process is precisely because the power doesn't exist in the first place. And the last point, accountability. One question that I think we may get to in the rebuttals is, well, what's the big deal here? Congress could do the same darn thing if it just imposed a tax on people and then imposed the mandate on the insurers to provide this service. There's a big difference. It's accountability. If the federal government had said, you know what, we're going to raise everybody's taxes and we're going to impose these independent mandates on the insurance company, both the insurance companies and the citizenry would have rose up and this statute would not have passed. What happens here is essentially you have a desire to impose mandates on the insurance industry. If you just did that directly, the insurance industry lobby would have gone wild and they would have stopped this from passing. One way to deal with that is raise taxes to pay essentially off the insurance companies. Instead of doing that, that's what the mandate does. It forces otherwise healthy people into the insurance market, which is no different than giving money to the insurance companies. If you strike down the individual mandate, you restore accountability to the system. You force the government, if it really wants to raise taxes, to actually say that that's what it's doing.
Professor Tribe, 7.5 minutes for rebuttal.
Thanks. It's remarkable how much Paul and I agree about. I think we both agree that the national government is a government of enumerated powers. I, too, start with the text of the Constitution. Congress has the power to regulate commerce among the several states. Question, in this case, is whether it's regulating commerce. Paul says it's not regulating commerce, it's creating commerce. There's no philosophical difference. Chief Justice Marshall in Gibbons made it clear that the power to regulate commerce is the power to lay down a rule about commerce. That's why I think Judge Silberman said that there is a perfect symmetry between the power to forbid or condition entry into commerce and the power to demand it. That's why in Wickard v. Filburn, Justice Jackson said that the fact that the little farmer is forced in everything but name to go on to the interstate market in order to buy what he could otherwise produce for himself. And the fact that the law operates by stimulating and creating commerce and not by restricting or forbidding it doesn't undermine its validity. This is a regulation of commerce. It's important to recognize that. It's important to recognize that the reason there have been relatively few cases in the modern period that have found that Congress has exceeded its power is that it takes an enormous amount of political energy and clout to get one of these regulations passed, unless Congress is simply doing something that's symbolic. I mean, look at what the ban on guns near schools did. There was no interstate problem that it was addressing. It was simply doing something that states and localities could do for themselves. It could say, we want gun-free school zones. In the context of the Violence Against Women Act, piling an additional federal cause of action on top of the local causes of action was not solving a collective action problem at the national level. It was simply grandstanding, showing that the government believed seriously that violence against women was a problem. But it's rare that one can identify a serious interstate economic problem of a magnitude that this one illustrates, and demonstrate, as Congress did carefully, that people, by virtue of their decisions to wait until the last minute and not to insure, but then to impose severe burdens on others in terms of higher premiums and higher taxes, was causing a problem. Yes, it's been 200 years before a situation presented itself in which this seemed like the optimal solution. Congress didn't, in fact, have the political capacity to do this through a single-payer plan, to simply expand Medicare, which would have, in fact, been a more severe restriction on liberty. What it did have was the ability to do a finely tuned solution to a fundamental problem. The fact that Congress has the power to prevent insurance companies from discriminating against people with pre-existing conditions and people with difficult medical histories is not in question. But when it exercises that power, it creates a problem for the insurance industry that it solves by broadening its base, by requiring individuals either to purchase insurance or pay a higher tax. The alternative to that, in terms of a straight-out tax solution, which Paul says would be fine except for the problem of accountability, is not simply raising everyone's taxes and then giving them a rebate if they purchase insurance. Rather, as Judge Kavanaugh pointed out in his dissent in the D.C. Circuit on Tuesday, the alternative would be something that wouldn't really change the thing politically. He says it would be a minor tweak to the current statutory language that, in his view, would definitively establish the law's constitutionality under the taxing clause. And that is to make clear, as this law functionally does, but doesn't in so many words, that anyone who chooses not to purchase the mandated insurance and instead pays the tax penalty is not a lawbreaker, is acting lawfully. If that language were included in the law, Judge Kavanaugh says there is no doubt that it would be a valid exercise of the taxing power. So it seems to me that what is dressed up as a principled argument about limiting national power and preserving liberty and preserving state sovereignty is really the attempt to take advantage of a linguistic quirk in the law and not to point to any fundamental flaw in it. Of course, the national legislative power is limited. The question really is this an exercise of the commerce power? Under existing doctrinal formulations, that turns on whether someone's decision to remain uncovered by insurance is properly understood as an economic activity, unlike having a gun near a school or committing an act of violence against a woman. Is it an economic activity? It seems to me it clearly is. And one point of agreement here is that if Congress operated this law to say that you don't have to get insurance in advance, but the moment you go to a hospital, you must become insured or pay a penalty, a tax penalty, because then you have entered the second stream of commerce that Paul is describing, the stream of commerce for health insurance. There's no question the law would be constitutional. So the issue is, does it become unconstitutional because Congress is acting on probabilities, on a forecast, on the fact that you don't know exactly when you will suddenly get hit by a bolt of lightning or by a truck or have a stroke? And therefore, it says, we don't want insurance rates to go up, we want people to be insured in advance. That's the whole difference. In addition to the simple linguistic difference to which Judge Kavanaugh points, that's the whole difference between the law that the 26 states that are suing the United States government, in this case, believed would be constitutional because it wouldn't operate until you've entered commerce. And this law, which Paul describes as forcing you into commerce. But I think that's really a verbal trick. I think that Judge Sutton was right when he said that the only difference between acting in anticipation, the way Congress does often, and acting at the moment you consume a commodity is a policy difference, not a constitutional one. And it's not so unusual, so extraordinary, that it would require 10 more provisions of the Bill of Rights to say that Congress has this power. As Judge Silberman pointed out just Tuesday, there are all kinds of cases when someone is not yet engaged in commerce. He's growing marijuana at home for home consumption. He's consuming child pornography at home, where Congress has reached its long federal arm and been upheld in exercising national legislative power. On the theory that that kind of activity can be reasonably forecast to have significant interstate economic impact. It seems to me that once Congress exercises those powers, we don't need a 20-provision Bill of Rights. What we need as a recognition is that there is a line between economic and non-economic activity, and that the fundamental protection of liberty, it's a capacious term, you don't need 10 additional provisions, is enough to protect the liberty that's involved here. Thanks very much.
Paul Clement, 7.5 minutes.
I too will start with common ground, which is I do agree that there are other ways that Congress could constitutionally, in theory, achieve its objective. Now, I rather doubt, because of the accountability that would come with those alternative means, that the legislation would actually pass. But in my mind, the fact that there are alternative ways to achieve the policy goal, if it is a desirable policy goal, which we both agree is eminently debatable, the fact that there are alternatives, to me, suggests strongly that we should not lightly want to sacrifice our liberty in this way and allow this kind of mandate. Now, let me say also one area of disagreement. I mean, certainly there is this notion that, well, how different is this from the government's regulation of child pornography or marijuana or anything else where there's a possessory federal government regulatory power? And the big difference is you can avoid in all of those other cases the regulatory reach of the federal government. If you don't want to be subject to possible prosecution under the child pornography statute, don't look at child porn. If you don't want to be subject to prosecution under the Controlled Substances Act, don't grow marijuana. But there's absolutely no way whatsoever you can avoid the long reach of the federal government under this statute. You must buy insurance, and you must buy it now. A couple of words about language. Professor Tribe is an eminently terrific advocate, so his words, I think, are well chosen, but a bit euphemistic. What's going on here in terms of the insurance industry is not a mere broadening of the base. It is forcing people who would rationally decide to self-insure to buy health insurance that they don't want for the benefit of the insurance companies. That seems to me to be a dangerous precedent to set. Nobody likes taxes. If you can disguise the taxes by basically forcing people to do things that they economically, rationally wouldn't do for the economic benefit of some other party who you then give additional regulatory burdens on, boy, that is a neat trick to circumvent all of the accountability that comes with the unpopularity of raising taxes. One more thing, another great euphemism on the other side is that the difference between these various approaches is just a linguistic quirk. I don't think so, but I'm willing to test it, which is to say, I'll take any of the alternatives that Judge Kavanaugh or Professor Tribe come up with, and I wonder whether they would pass the Congress of the United States right now. I doubt it, because I think people, if they were told that this was unambiguously a new tax, there would not be the political force to pass it. But if I'm wrong, so be it. That's accountability. That's the democratic process. If this can be done while respecting people's fundamental rights to liberty and the fundamental structure of our government where the federal government does not have unlimited powers, so be it. as I say, this really isn't about the policy. It's about the Constitution and whether this is an available means to the federal Congress to achieve this objective. I continue to think, and I haven't heard anything to the contrary, if you can do this, then why can't you force people to buy new cars instead of the nettlesome incentives of cash for clunkers and the like? And I think to make this, and I'll make this essentially my last point, I think you have to understand now, as Professor Tribe suggests, go to the Court's Commerce Clause jurisprudence. So what do they get to do in regulating commerce? They get to regulate instrumentalities of commerce. Well, this is clearly not that. They get to regulate the channels of commerce. This is clearly not that. So if it's anything, it must be the good old significant substantial effects test, and you can aggregate this and that whole argument. Well, there's almost no economic activity or anything. There's no action that if you force all of America to do wouldn't have a substantial effect on commerce. So there is no limiting principle to the power asserted, and that becomes even more clear if you think about the doctrinal path to understanding the Commerce Clause in the Court's own jurisprudence. Now, this is one place where I think Justice Scalia and his race concurrence, which some people think hurts the challengers, I think really helps. Because what he recognizes is those first two, instrumentalities and channels, are the only thing that's a pure regulation of commerce. The substantial effects really should be understood as part of the necessary and proper analysis, that in certain circumstance, you get to regulate activity that has a substantial effect on commerce because to do so is necessary and proper to regulate commerce. So at the end of the day, then, the question here really boils down to the question of whether or not forcing people to engage in commerce because it is a convenient expedient to the government more efficiently regulating commerce is necessary and proper legislation. And I submit quite simply, it's not. It's not necessary. You can do it through other means, including the taxing power, if you have the political power to do it. And it's not proper because it's a direct assault on liberty, it's a direct assault on the residual sovereignty of the states, and it's a direct assault on accountability.
So that concludes the formal part of our structure here. We're going to have a slightly more informal discussion up here, and then we're going to take some questions from the audience. Please notice there are two mics in the house. If you want to ask a question, you might move toward the mic and begin to line up while we discuss a couple of points up here. I'll take the moderator's privilege to just ask a couple of questions. Professor Tribe, your colleague Charles Fried was here last year on a panel taking your side of this debate, and he...
I would call it the Constitution's side.
And he forthrightly conceded, acknowledged that on his theory, the government could actually require you to buy a certain amount of broccoli per week, so the infamous broccoli hypothetical. Yes. Do you agree with your colleague that the Congress could do that?
Well, I don't like broccoli as much as Charles. And I think that if I were focusing on what the court should do in upholding this law, I would suggest that if it's to be upheld, it should be upheld on the narrowest possible ground. But it is true that if there were the political will to improve the situation of the broccoli industry by requiring everyone either to buy a certain amount of broccoli or pay a corresponding tax for not doing it, that nothing in existing doctrine would get in the way. I think my colleague Charles Fried is right about that. I think to some extent that is what Judge Silberman was saying when he said that the power to compel someone to engage in commerce, though it may look more dramatic than the power to prevent it, is every bit as broad when there is significant interstate impact. After all, a government that can prevent you from possessing any number of apples or any amount of broccoli on the theory that there is some impact on interstate commerce is probably also a government that could require you to purchase it or pay a tax. But the primary inhibition against such absurd exercises of the commerce power has always been political. It's always been the fact that Congress cannot lightly get what is required in terms of legislative majorities to do fanciful things. It's not an accident that it took 4 decades to get even this compromise bill passed. It's because it's extraordinarily difficult to get Congress to agree on a regulation of commerce that goes this far. And to some extent, I think Paul's suggestion is that it was done by legerdemain. People were deceived into not recognizing that although this is called a mandate, it can't be enforced by criminal punishment, it can't be enforced by anything other than civil tax enforcement. But I don't think people were fooled. Everyone knew there were at least 6 senators and 5 members of the House of Representatives that said this is an exercise in part of the taxing power. It's not a tax, but it uses the taxing power to enforce a regulation. And the fact that it's a long bill, that lots of people haven't read all of it, doesn't seem to me to be too relevant. Chief Justice Rehnquist, in a case in 1980, made the, I think, astute observation that if a law were to lose some of its constitutional validity because someone in Congress or in the public didn't read every one of its provisions or misunderstood part of it, then virtually nothing that Congress enacts would be constitutional. Now, for some, I understand. Paul told me that when I agreed to come here, I was entering the lion's den, and I didn't expect you to be pussycats. But it seems to me that there is really no problem of political accountability with this law. The law does push rather far, but not beyond the limits the court has already established.
Paul, any thoughts on broccoli?
Well, one of the things I was most happy about in the 11th Circuit argument was that I think both sides got through it without a reference to broccoli. But I just, I appreciate the candor of Professor Tribe's response, and I think it nicely encapsulates the point that I was making, which is simply there's no limit on this power. And to Professor Tribe's credit, he embraces that, but I think it's a rather chilling prospect that the federal government could force people to buy broccoli. I think the proposition that anything that the federal government could forbid in interstate commerce they can compel, I also think is kind of a chilling prospect. And I think the answer to it really gets back to, you can go all the way to Gibbons against Ogden, and the principle that the commerce power, as Professor Tribe said, is the power to prescribe the rule for commerce. But forcing you into commerce so you can be better regulated in commerce is not, in my view, a rule of commerce.
Can I just pursue this? Because the question that I had, which I sort of thought, Paul, that you might address, is the question, what happens when the law doesn't kick in until you are consuming health care? It says that when you go to a hospital to get medical care, you have to either pay for it, or if you can't pay for it at that moment, you have to get insurance. And if you don't purchase insurance, then you're going to be subjected to a penalty. I think you conceded in the 11th Circuit that they could even say that you must be insured at the point that you are consuming health care, even if you think it's not in your own rational interest to proceed that way. So what's the difference between that and saying we don't want to wait till the last minute? We want to require that people swim not in the nude, as it were, that they be covered in advance. You can make it sound sort of draconian by saying that you are being forced to engage in commerce, but we do that in a number of ways.
And I guess to me, the difference is liberty, because it may be that every one person is eventually going to be in a position where they're going to want to purchase health care. I mean, I could quibble and say that, well, actually not everybody, because some people are just going to die in their sleep and they're not going to need any health care, but that's a debater's point. I'll concede that the vast majority of people are eventually going to buy it. But on the other hand, if I'm a healthy person in my 20s, I wish I were a healthy person in my 20s. If I'm a healthy person in my 20s...
You wish you were.
If I were a healthy person in my 20s, I could make a rational decision that I'm very unlikely to have to buy any health insurance at all in the next 10 years, and I could use my limited resources to buy things that I actually wanted to, and as an exercise of my own autonomy, I decided to purchase instead of what the branch of government, the level of government most removed from me as a citizen is forcing me to purchase.
So now Professor Tribe took on the broccoli hypothetical. For you, there's the infamous vaccination hypothetical. So in a case of some runaway, horrible, contagious epidemic, On your view, Congress would lack the power to require folks to be vaccinated?
Well, I mean, you got to tell me why vaccination is an exercise of the commerce power at all. I mean, I think that the rational way for Congress to deal with that is if there's a runaway epidemic. I mean, why? And I guess
the runaway academic.
I guess I would say, as to both the runaway academic and the runaway epidemic, that the answer lies in the state governments. I mean, there's no reason at all why the states, which don't have the similar constraint and actually do have the police power, can't force people to get vaccinations. I mean, that seems to me to be a classic exercise of the police power, and I don't really understand, but maybe you can illuminate it for me. You know, what does that have to do with commerce at all?
So people are not going to die, and they'll be able to go out and engage in commerce.
Well, I'll just, you know, I hate to wax, use Latin, but res ipsa. I mean, if that's the argument, I can live with it.
Fair enough. Okay.
But there is a big difference between the vaccination hypothetical. There are obviously limits on what any level of government can do to us. It can't necessarily make us, and I think it shouldn't be able to make us, accept unwanted medical care when third parties aren't going to be affected. On the other hand, if I'm a contagious disease carrier, then the state or locality, and I agree it probably is not going to be Congress, can make me get vaccinated. But there are certain problems that intrinsically and structurally can't be handled purely at a state or local level. The problem of insurance companies imposing rules about pre-existing conditions and charging for insurance on the basis of your own medical history rather than the community's history. If you regard that as a problem, and Congress is entitled to, is a problem that can't be solved at the state and local level very well because of the race to the bottom. Because if one state alone decides to impose certain restrictions on the practices of its insurance industry, or to be more generous to patients, it's going to lose part of that industry to other states. That problem is a problem that concerned the framers. They thought it was important, and that's why they gave the power to regulate commerce among the several states to the national government, in part. Concerned the framers. The problem of spillover effects, situations that can't be handled at a state and local level. That's not true of most of these other examples. Vaccination can be handled locally. Guns near schools can be handled locally. Domestic violence can be handled locally. If you want a general limiting principle, and broccoli, by the way, can be handled locally, if you want a general limiting principle, it's that not only is Congress limited in regulating economic as opposed to non-economic activity, but it may well be limited in tackling problems where there's a plausible showing that there's a need for national action, where it's not something that could be solved entirely well by having mini Romney cares in 50 different states. And that, I think, is a fundamental difference. And it's a difference that can be expressed in constitutional doctrine.
I see that our audience is anxious to get in on the debate here. Let's start over here. Ilya Shapiro, the Cato Institute.
Thanks. I have a question for Professor Tribe. I'm going to pose the question that Adam Winkler of UCLA called the gotcha question in our symposium on SCOTUS blog this summer that Professor Tribe and I and many others here participated in, and that is, and whether you can want to answer as yourself or were you the Solicitor General when that question does come up, if this mandate is allowed to go through, then what can the government not force us to buy?
It cannot force us to buy a product without a showing that there is a serious national economic problem to which the failure to buy that product is an answer. It seems to me that that limitation, which is a limitation, I mean, for example, I don't think it can force us, although there is historic practice behind doing it, I don't think it can force us all to buy a gun in order to be well armed to prevent burglaries, because that's something that can be handled at a state and local level. The Second Amendment confers a right to bear arms, not necessarily a right not to be forced to purchase them by the state or local government. But Congress can't do that. It seems to me that the limit of Congress's power is not a new limit. It's a limit that was elaborated in both Morrison and in Lopez when the court said that in regulating something other than the instrumentalities of commerce, or commerce itself. One is limited to regulating activity that is economic. And if it's economic activity, as I tried to argue, the activity of deciding how to finance your inevitable purchase of health care is economic activity, then you can look at its aggregate impact on interstate commerce. But if it's not economic activity, you can't. It seems to me that what makes the health care situation quite distinctive is essentially that everybody is going to purchase it, and the question is, how is that purchase going to be financed? And that's what makes it economic.
I'm going to let Randy ask the follow-up.
He was coaching you, but he can do it better himself.
He told me not to ask the follow-up because he's going to take it.
Oh, okay, sorry.
We're going to go over here next, and then we'll come back to Randy.
Professor Tribe, although I've enjoyed hearing you since the first time I heard you 32 years ago, I must confess you undercut your credibility and almost caused a great spit take at my table when you referred to the extensive study Congress put into this act. Given that there were no committee hearings on this act, do you think that undercuts a little bit of the deference that Congress should be given? But more importantly, given the lack of a severability clause in this legislation, if the individual mandate falls, I'd like to ask both speakers to answer whether or not they think the entire act must fall.
As to the question of study, it's an issue that Congress had in fact studied over a long period of time, but I think it would be terrible to have a judicial doctrine that has the court looking behind the findings that precede an act to say, you guys didn't really know what you were doing. I think the separation of powers is at least as important a value as federalism in this context, and that it's not at all up to the Supreme Court to decide that Congress didn't quite know what it was doing, didn't have the right experts before it, when there are empirical findings about the billions of dollars of uninsured costs that are shifted to other people. I think that Congress is entitled to have those findings taken at face value. As far as severability is concerned, I have to admit I'm agnostic. It seems to me, on the one hand, that this provision is extremely important in the operation of the Act, at least with respect to those corresponding provisions that deal with restrictions on industry practices. That if this falls, then there's a very strong argument that the provisions dealing with pre-existing conditions and community rating as opposed to individual medical rating may well have to fall as well, but that there are other provisions of the Act about the interstate exchanges and other provisions that don't need to fall. But every imaginable point on the severability spectrum has been taken by one court or another. Some courts have taken the view that the whole Act falls if the individual mandate does. Others have taken the view that you can surgically excise the individual mandate without affecting the rest. And I have to say I'm not ready to take a clear position myself on that.
Paul, do you have any comments on severability? And in particular, is it surprising at all that the Solicitor General is taking the position that the Act is inseverable?
Well, a couple of things. One is, I represent clients, and my clients take the position that if the individual mandate falls, then the rest of the Act falls. And I think that, that there are other possible outcomes, as Professor Tribe says. We've now had, obviously, only courts that strike down the individual mandate reach the question of severability. We've had 4 courts that have struck down the individual mandate as unconstitutional, and the 4 courts have come up with 4 different results as to severability. So it's clearly, an issue where I think it's a little bit difficult. The SG, at least as I understand it, certainly this was the case in the 11th Circuit, actually does not take the position that there would be no severability, but actually does think that certain provisions presumably would be kind of joined at the hip with the individual mandate. So I think it's really not a question, although the 11th Circuit, as I read the opinion, really severed nothing or struck down nothing else besides the individual mandate. I think it's really not a question of how of whether some other provisions go. It's just a matter of how much would fall with the individual mandate. If I could circle back just on 2 points that have come out in the Q&A. One, again, a lot of this comes down to how you characterize things, and I do think Professor Tribe has argued that the decision to whether or not to purchase health insurance is at some level economic activity. I mean, I think just it's another very simple way of looking at it is if you're sitting there in your living room and you don't want health insurance, you're not engaged in economic activity. In fact, you're consciously avoiding economic activity because you've made a rational decision not to buy insurance. And so to have the government come in and regulate you at that point does not strike me as the regulation of economic activity. The only other point that I would make is, I think Professor Tribe has suggested maybe something of a limiting principle in terms of the idea that maybe there would need to be some showing that the mandate that the government adopts in a particular setting is necessary to solve a truly national problem and something that can't be solved at the state level. And to the extent that, I don't want to use a loaded term, but to the extent that that can be called a concession, at some level I welcome it. But I do think in these Commerce Clause cases, the court wrestles between sort of two impulses. On the one hand, I think they very much believe that because the process of enumeration suggests some power not enumerated, there has to be a limiting principle. The other thing, of course, they worry about, though, is administrability. They want to come up with a rule that they can actually administer in a variety of cases. And I do worry that the proposed limit that, that this power only exists in cases where it's really important for Congress to solve a truly national problem is going to be a very difficult line for courts to police. They would probably default to deferring to Congress whenever they said, oh, guess what, this too is a really important national problem that the states can't solve. And it seems to me that in that world, the alternative of a very administrable rule that says, look, Congress has never forced people to engage in commerce for 220 plus years. Let's keep it going. Let's not allow Congress to have that power. That's exceedingly administrable, and there's a limit on the commerce power.
Randy Barnett, Georgetown Law School.
Thanks. I knew that if I stood up here long enough, most of my question would get asked and answered. But I do want to emphasize a point that I think came out in the exchange between Professor Tribe and Ilya and also the gentleman over there. And that is that to the extent the healthcare is a unique kind of market activity and that is the limiting principle. I mean, maybe the honest answer is there is no limiting principle. It's a political principle, which at times I think I heard Larry say. And I think that is sort of the honest position that Judge Silberman adopts, that in principle, he said there's an imperative that if there must be a national power to handle national problems. That's his final paragraph. And that means there is no limit. And if that's what the government wants to live with, that there is no limit, then they can see if there's 5 votes for that. But if, in fact, there's going to be a limiting principle, and the limiting principle is somehow based on the uniqueness of the healthcare market, then there has to be some way of deciding whether, in the next case, whatever underlies that limiting principle exists in the next case. And so my question really concerns, what would that look like, doctrinally? What would that look like? If the answer to that is what your answer was to the previous questioner, which is that the court should defer to Congress's on a rational basis grounds, that Congress has acknowledged the existence of a national problem and there should be deferred to. If the next time they identify a national problem, or the next time they identify uniqueness, or whatever makes this healthcare business unique, they find those factors present again. If the standard of deference is going to be rational basis, then there is, again, no limiting principle. And everyone knows that, and the court will know that there is no limiting principle if it's rational basis. But if it's not rational basis, then what is it? And whatever it is will bring us back to the days in which the court does scrutinize economic regulations to see if it's truly rational, it's truly justified. That's an exercise that the court has gotten out of in the past. I don't think they're necessarily comfortable getting into it today. But I ask you, Larry, if it isn't going to be a rational basis to determine whether the next market good that's mandated is a unique good, then what is it going to be?
It seems to me that both Judge Silberman and Judge Sutton as an indispensable part of his reasoning and Judge Silberman as a kind of alternative holding, said that it is very clear, not really in dispute, and therefore not the kind of finding to which you really have to worry about the level of deference, that the healthcare market is unique. That is, because of the legal and cultural features of our society that require people to provide healthcare free of charge in emergency circumstances, even if people have not taken advance measures in order to pay for it, in order to have it covered by insurance. That feature of the market makes it palpably, manifestly unique. unique in the sense that it is relevant precisely to the claim that people are being forced to engage in a kind of commerce that they wouldn't otherwise engage in. Commerce in healthcare, as opposed to commerce in health insurance, is something that, like it or not, and most of us don't like it, we are swimming in all the time. Now, if you say that the Constitution doesn't itself point to that as a relevant factor, I would say, of course not. But that's not critical. What's critical is that it enables you to distinguish the situation that people who choose not to provide in advance for the contingency that they will get health care that they can't pay for becomes an economic problem. It's an economic problem in a way that the decision not to purchase broccoli in advance doesn't present. The fact that the economic problem that makes this situation unique is one that enables you to say people are not really being forced to engage in a kind of commerce that they would otherwise simply avoid, although they would like to avoid it. The fact that that principle doesn't itself arise from the Constitution doesn't prevent you from invoking it in order to say, well, the mandate to purchase General Motors cars doesn't have that feature. It's not as though everybody is bound to be in the market for automobiles at some point, and therefore we're not really doing anything special by requiring them to buy it. So it seems to me that when Judge Silberman said that the unique characteristics of the healthcare market in this special respect prevent us from having the view that we are taking some massive leap by forcing people to make provisions in advance for payment, it seems to me that that's enough to distinguish it. And one doesn't get to the question of levels of scrutiny.
In the 11th Circuit, we are denying that the healthcare market is unique. The parties are denying that the healthcare market is unique or the health insurance market is unique. Now what? Do we have a hearing on that? And where, at what level does that hearing happen, and what is this level of review that the courts use to ascertain whether Congress has been within its power or not?
Well, I think that's, when you say they're denying that the health care market is unique, it's not clear to me what that denial really consists in. Are they saying we won't virtually all need health care, and because of the legal landscape, be able to obtain it without paying at the time? I don't think there's any denial about that. I think there may be a denial about how to characterize it.
I mean, I can give you a flavor for the argument, which is, I do think, there is a strong argument that the healthcare market is not unique in this respect. I mean, we have a proud cultural tradition in this country of not letting people starve. We have a proud cultural tradition of not letting people, walk around naked because they can't afford clothing. We also have a proud national tradition of having people whose houses are completely wiped out in a floodplain after a hurricane or something, of giving them funds to rebuild their houses. So there are other markets where we just don't let the people who didn't plan as well as we would have hoped them to have planned to just say, well, that's tough and we're not going to do anything. So I don't think the market is unique. But the point I'd like to circle back to, which is I don't understand why this discussion of uniqueness is really relevant, because uniqueness is not a limiting principle. It has nothing to do with the Commerce Clause power. The Commerce Clause does not say that Congress has the power to regulate commerce in unique industries. It is a power to regulate commerce. And if this can be defended, it can be defended on one of two rationales. It can be defended on the rationale that Congress has the power to compel anything it can prohibit, which is a principle that nakedly admits of no limiting principle, or it's defensible on the principle that if you aggregate all of the economic activity that's being compelled, that it has a substantial effect on commerce. And that too lacks any limiting principle. And so unless the court is somehow going to, with no textual basis whatsoever, overlay a uniqueness requirement on the Commerce Clause, I mean, I don't think this market is unique, but what if it were?
Well, it seems to me that of course it doesn't say Congress can regulate commerce only in unique industries. It says it can regulate commerce among the several states. The question is whether it is regulating commerce. The argument that at least Judges Sutton and Silberman found persuasive is that it is regulating commerce in this context precisely because the nature of human life is such that we're going to all need health care. And the legal background, which we do not have with respect to food, clothing, and housing, not just the emotional idea that we don't want to let people go without medical care. There are legal requirements and requirements in the medical profession that say you do not allow someone who goes to the emergency room and doesn't have an affirmative answer when you say, where's your insurance card? You don't allow that person to bleed to death. That legal background renders this market unique, and the reason that's relevant isn't that there is a word about a uniqueness in the Article 1, Section 8 of the Constitution, but that enables these judges to say that this is a regulation of commerce, because the question of how that commerce, which is going to take place, gets paid for, is itself an economic question.
And you had me right up until the end, which is, that they do have this argument about uniqueness, but ultimately their analysis doesn't turn on that. There's not, again, Judge Silberman says quite plainly, if Congress can prohibit it, then Congress can compel it. And Congress can prohibit broccoli in interstate commerce, I presume, and therefore they can compel it. And to the extent there's another analysis out there, it turns on the substantial effects and the ability to aggregate that which is being compelled. And so I hear an argument that this market is unique. I don't happen to agree, but even if it were, it doesn't seem to me to admit of a limiting principle of the argument that's being accepted by these courts of appeals.
Let's take another question for the audience.
Mario Loyola, Texas Public Policy Foundation. I'd like to take the point that Professor Tribe was just alluding to on the uniqueness of this, the healthcare inhering in the laws and rules that require the provision of free healthcare, because I think, if you'll allow, that leads right up to what I think is the fatal flaw in the idea that the limiting principle here can be a unique economic problem. I don't know what the basis is in constitutional law for that limiting principle, but assuming there is one, notice that this unique problem doesn't inhere in the area to be regulated, right? Because you have laws that you just referred to that require the provision of free medical care. So actually the uniqueness inheres in whether Congress has yet created a problem sufficiently huge to make the area unique and therefore require further regulation. And so I think that I don't see how a constitutional principle can say, a limiting principle under constitutional law can say, Congress can regulate this area but not that one, depending on whether Congress has already created a huge problem in that area or not.
I think that's to you.
Yeah. The question of what gives Congress the power to deal with something as part of a larger situation is one that recurs over and over again. In the Lopez case, for example, where Chief Justice Rehnquist said, you can't make it a crime to possess a gun near a school, he also said that if Congress had a comprehensive national regulation of sales of firearms interstate and sales of pistols, and the need to regulate the possession of a gun near a school was simply part of that larger scheme, that might well make it constitutional under the necessary and proper clause, even though Congress had in a sense created the occasion by having the broader regulation. Justice Scalia said exactly the same thing in his concurring opinion in the marijuana case in Raich. That is, even though Congress would not have had the power nakedly to go in and say to someone, you may not possess this particular marijuana plant, when Congress has created a national scheme of prohibition of interstate traffic in certain controlled substances, that gives it the power under the necessary and proper clause to make effective the broader power that it has now exercised. It seems to me that the necessary and proper clause, therefore, is the answer to your question. It's true that it creates a certain amount of bootstrapping. That is, that subject only to a political check, Congress can create the occasion for a regulatory action that might not otherwise be permissible. But that's what John Marshall, I think, had in mind in McCulloch v. Maryland from the beginning. That is, Congress has the power to do anything that is reasonably ancillary to the effectuation of its other powers. And if that gives Congress the power to augment its own authority, so be it.
See, we have
Professor Tribe
long lines at both mics, but I'm afraid to keep the trains running on time. We have time for one more audience question. We'll give the final word to Steve Calabresi.
Thank you. My question is for Professor Tribe, and I had a two-part question. First, Congress has adopted laws forbidding the sale of body parts and also of babies. This is a regulation of commerce. Could Congress compel people to donate blood, to donate a kidney in a circumstance where it was needed, or make some other compulsion of that kind? And then my second question is, isn't this a law that basically takes the property of a private party and gives it to B, another private party, and therefore isn't the law flawed insofar as it imposes a tax, but the benefits of the tax go to a third party rather than into the general treasury?
Well, let me take those questions in reverse order. It seems to me that both in Kilo, or Kylo, I never know how to pronounce it, and in Hawaii Housing Authority v. Midkiff, the court made clear that even though the way a law operates is to make one private party better off and another worse off, as long as, if it's an actual taking, there is just compensation, and as long as there is a defensible public purpose under a minimum rationality standard, that's not a fatal objection. And I don't think that this case would provide an occasion for revisiting that. As to your question of mandated donation of body parts, happily, I think my own answer, I hope, is where yours would be. I don't think either Congress or the states would have the right or the power, even if it could be shown, to create some aggregate benefit for the public, because the people who need the donated liver or the donated kidney need it even more than I do. And even if there were just compensation, I don't think it would have the power to mandate that, because it's quite clear that that would be a significant deprivation of personal liberty without substantive due process. Now, that does lead one to challenge, to some extent, Judge Silberman's suggestion of absolute symmetry. Right. That is, it is not always the case that the power to forbid something entails the power to compel it. The power to forbid and the power to compel may not travel as companions. But the doctrine that limits the tight linkage between prohibition and compulsion is essentially a doctrine in the unenumerated arena of substantive due process. And I don't think it's a doctrine that can be meaningfully elaborated in terms of a limit on Congress's national authority.
Clearly, we could go for hours more, but I'm required to tell you that the next panel begins directly across the hall immediately, in a matter of moments. It's on the topic of a federal sunset law, and it promises to be an excellent panel, so please join us over there, and please thank our debaters.